The rain was tapping the porch roof like a patient drummer the night I first heard about Ella stepping onto the sidewalk with her newborn cradled against her chest. She whispered later that the air felt heavier than the child in her arms, because every raindrop seemed to say the same terrible sentence: "You are no longer welcome here." Inside that brick house, her younger brother Adam was bolting the door and telling the police on the phone that a trespasser refused to leave the property. In one breath, he erased the history of shared bedrooms and scraped knees and bedtime secrets, downgrading his own sister to an unwanted guest. I sit here now in this worn leather chair, the ticking of an old clock behind me, trying to picture the scene the way the patrol officers must have witnessed it. Ella's shoes muddy from the front garden, her baby fussing while blue lights bounced across the wet pavement, a frazzled rookie officer reading from a clipboard, explaining that without proof of legal occupancy, he could not force Adam to open the door. Ella reaching for the blanket slipping off her child's tiny feet, her voice cracking not because of the cold, but because something colder was dawning on her. The realization that family alone is not a legal right of entry. Most of us grow up believing that siblings argue, then reconcile over holiday pies, that whatever storms pass through a house never quite uproot the foundation poured by parents. Yet probate court dockets across the United States tell a different story every week. Property lines can cut through bloodlines. A single signature on a deed or a missing one on a will can turn Christmas cards into subpoenas. Ella's parents had passed within a year of each other, and in the fog of funeral planning, nobody could remember seeing a formal will. Adam took charge of the mortgage payments and, perhaps emboldened by monthly withdrawals from his own overstretched business account, gradually spoke of the house as his. At first, Ella did not contest it. She was navigating prenatal checkups and saving every dime from a part-time job at the library. The house felt sturdy, the relationship felt sturdier. Until the baby arrived and hospital bills arrived, and Ella asked whether she could move back into her childhood bedroom for a few months. Adam said yes with a smile that, in hindsight, looked rehearsed. He told neighbors it would be lovely to have a baby's laughter in the hallway again. He helped paint the crib white. Yet the day the last hospital invoice slid into the mailbox, Adam's tone changed. He mentioned refinancing. He hinted at selling. He blamed the crying for his lack of sleep before important client calls. On a Tuesday morning, while Ella was at a pediatric appointment, he packed her suitcases. By nightfall, he had changed the locks. When Ella phoned me from a motel 6 miles away, her voice quivered between disbelief and determination. She needed a shower, formula, and a plan. I knew enough landlord-tenant jargon to suspect that something was off. This was not a standard roommate dispute. But the law does not run on gut feelings alone. It runs on documents, dates, and definitions. The next morning, Ella walked into the county courthouse, baby carrier in hand, and asked the clerk how to file a wrongful eviction claim. The clerk, a grandmotherly woman with reading glasses hanging from her neck, waved fingers toward a stack of pamphlets and said, gently, that family disputes often end on the probate side of the building. That single hint cracked open a memory. Somewhere, tucked between photo albums and old tax forms, Ella's father had once mentioned drafting a new will after retiring from active duty. Nobody had seen it since. But a will, if valid, could redraw every conclusion Adam thought he had reached with a locksmith's wrench. Across town, a young attorney named Marissa Collins took Ella's call. Marissa specialized in civil housing cases and had a reputation for speaking plain English to clients who could not afford jargon. She listened, she took notes, and she scheduled an emergency injunction hearing for the following week. Yet before she stepped into the courtroom, she made one request of Ella: search every attic box, every safe deposit receipt, every email. Find that will, because in American law, paper is power. I pause here, looking at the camera, because this is where most stories end for those who do not know their rights. They sleep in cars, they couch surf, they accept the narrative that possession is 9/10 of the law. But that old saying ignores the other 10th, the decisive slice that belongs to statutes, case precedents, and due process. Ella's hunt for the will became a race against despair. She called a distant aunt, a former family accountant, the notary who handled her parents' refinance years earlier. Days blurred into nights, lullabies shared with photocopiers and bankers' boxes. Finally, in a metal filing cabinet labeled household repairs, beneath manuals for long-discarded appliances, she found a sealed envelope embossed with an attorney's crest. The date on the flap was 3 months after her mother's funeral. Inside, 2 wet ink signatures bequeathed the house not jointly, but exclusively to Ella, provided she cared for any minor child under that roof. When Marissa unfolded that document in court, the room fell silent, except for the scratch of the judge's pen noting its entry into evidence. Yet this turning point was not a cinematic twist. It was a reminder baked into every state probate code. Wills speak beyond the grave, and the law listens closely. So here we sit, you and I, on a quiet evening that feels safer than the night of the eviction. Perhaps you are sipping coffee, maybe nursing your own questions about family and property. I invite you to lean in, because the pages of Ella's case reveal more than sibling rivalry. They reveal how the justice system measures words like home, caretaker, heir. And they hold lessons that could one day keep your porch light on when the rain starts. The week that followed felt like a slow-motion newsreel, every frame soaked in tension. Ella started it by negotiating with the motel manager for an extension, promising that her emergency assistance voucher would clear before checkout. She patted the bathroom sink with a towel so her infant could nap close to the steam of a hot shower, the only warmth she could afford while the room heater rattled. I remember her calling me at dawn, her phone balanced on the lid of a diaper bag while she mixed formula with bottled water. She spoke softly, as though the walls themselves might judge her for planning a lawsuit against blood kin. Adam, meanwhile, doubled down. He posted a notice on the front gate declaring that any unauthorized entry would be prosecuted. He listed the house on a short-term rental site, snapping photos that cleverly skirted family portraits still hanging in the hallway. Within 48 hours, a couple from Omaha booked a weekend stay, unaware that the nursery they admired online had been painted with Ella's own hands 3 months earlier. When the couple arrived, Adam handed them a key and a scripted story about a sister who had moved across the country. He even pointed at the freshly changed locks and joked that you can never be too careful with security. That decision, letting strangers occupy disputed property, lit the first real fuse in the legal canon. Marissa filed an emergency motion for a temporary restraining order, arguing that Adam was engaging in what many states label as self-help eviction. Under Section 6 of the Uniform Residential Landlord and Tenant Act, a landlord can never bypass formal court procedures to force someone out, much less rent the space to tourists while a rightful occupant stands outside. Several jurisdictions enhance the penalty when the evicted party is caring for a minor child. Marissa attached photographs of the online listing, the reservation receipt, and an affidavit from Ella describing the midnight lock change. The clerk stamped the paperwork with a date 15 days out, the fastest slot the crowded docket allowed. 15 days is an eye blink for a historian, but an eternity for a mother who counts her baby's age in weeks. Ella spent the interim babysitting at a local church to cover motel fees, and with every changing table she wiped, she rehearsed the testimony she would soon give. On day 5, Adam sent Ella a text. "House is mine until proven otherwise. Stop harassing me." The message might have vanished into the endless gray of sibling bickering, if not for the last line. "I will press criminal trespass charges if you set foot on the property." Marissa printed the screenshot. Threatening prosecution without basis can constitute intimidation under many state tenant-protection statutes, and judges do not appreciate litigants who weaponize law enforcement to settle private scores. Day 8 brought a development no one predicted. The couple renting the house discovered a forgotten baby monitor still paired to Ella's phone. While exploring the nursery, they bumped the camera. It activated. And somewhere across town, Ella's screen lit up with a live feed of strangers deciding whether the wallpaper was too pastel. She watched in stunned silence, feeling equal parts powerless voyeur and rightful guardian. Instead of sending an angry text, she forwarded the clip to Marissa, who immediately added it to her evidentiary file. Surveillance footage showing third parties enjoying disputed space often resonates with juries more than spreadsheets ever could. Meanwhile, community gossip circulated faster than court notices. A neighbor posted on a local message board about the brother who Airbnb'd his sister's crib. Some defended Adam, arguing that financial strain justifies tough choices. Others recalled seeing Ella mowing the lawn while pregnant and wondered why any sibling would deny shelter to a newborn. The thread grew heated, touching on broader issues of housing insecurity, mothers' rights, and the rising trend of short-term rentals displacing families. By the time moderators closed comments, local reporters had caught wind. A young journalist from the county daily left a voicemail for Adam requesting his side of the story. Instead of returning the call, he fired off a cease and desist letter drafted from an internet template, accusing the paper of libel if they published unverified gossip. Ironically, that threat only pushed the newsroom to verify every detail. They obtained police dispatch logs confirming Adam's trespass call on eviction night, public property records showing both siblings listed as potential heirs pending probate, and an interview with the motel manager who described Ella's late-night check-in under distressed family rates. All of this unfolded before the court even scheduled a first hearing. It illustrates a gritty truth about American civil disputes. The legal process often lags behind public perception. Statutes promise due process, but reputations live in real time. On day 12, Adam's lawyer, retained hastily after the restraining order filing, tried to negotiate. He offered Ella 60% of any future sale proceeds if she would drop all claims and sign a quitclaim deed. Marissa countered with a simple sentence: produce the original will or prepare for trial. Silence followed. By day 14, the Omaha couple checked out, leaving a glowing review about the cozy family vibe. They never knew the nursery cameo would soon appear as evidence in a Superior Court slideshow. At sunrise on the hearing date, Ella dressed her infant in a onesie printed with cartoon scales of justice. Maybe it was corny, but it reminded her that the courthouse could feel like a cradle rather than a coliseum. She arrived early, clutching the manila envelope that held the will, plus a pocket folder labeled receipts, diapers, formula, motel, gas, pediatrician co-pays. Each receipt represented not merely money spent but harm suffered, and under tort theory, those harms might translate into compensatory damages. Inside the courthouse hallway, Adam paced beside his attorney, occasionally glancing at the courtroom door as if it were a locked exit he might pick. He carried no paperwork beyond a single spiral notebook. When he noticed Mom's engagement ring on Ella's finger, a ring Ella wore since the funeral, his expression flickered between nostalgia and remorse. Then the bailiff called the case, and emotion yielded to procedure. I want you to picture the courtroom the way the baby might have seen it, wide-eyed from the gallery. Hardwood benches smelled faintly of lemon polish, a state flag draped behind the bench. The judge, robe draped over a gray suit, read the file summary aloud. Petition for temporary restraining order, claim of wrongful eviction, motion to admit last will and testament. Legalese can feel sterile, but every syllable described nights Ella rocked a child in a borrowed crib while her brother collected rental income. Marissa began with the eviction timeline, weaving statutory references into plain sentences. She cited California Civil Code Section 789.3, which forbids lockouts and permits statutory penalties of up to $100 per day. She referenced the Uniform Residential Landlord and Tenant Act, reminding the court that a landlord, or in this case, a co-heir, posing as sole owner, must obtain a writ of possession before removing an occupant. The judge nodded, perhaps picturing hypothetical jury instructions with those same statutes bolded. Then Marissa produced the will. The seal glinted under courtroom lights. She slid the document forward, pointing to the clause that devised the entirety of the primary residence to Ella, contingent upon occupancy with any minor child until that child reaches majority. The judge examined the signatures, the notarization date, the attorney's certification. Verification was swift. The drafting lawyer was still in practice and reachable if needed. Adam's attorney objected on grounds of undue influence, claiming the will appeared after a suspicious delay. Yet he offered no affidavit, no handwriting expert, no alternative testamentary document. The judge overruled the objection, reminding counsel that allegations require evidence. In 5 minutes, the will entered the record. With the dispositive document on the table, the hearing shifted to immediate relief. Marissa requested that Adam be ordered to vacate within 72 hours, that all rental proceeds be deposited in escrow, and that Adam pay statutory penalties dating back to the lock change. Adam's counsel pleaded for more time, arguing that the guests had already departed and no harm was ongoing. Marissa quietly placed Ella's receipts atop the podium, a stack tall enough to tilt sympathy. The judge granted the restraining order, awarded temporary exclusive possession to Ella, and scheduled a damages hearing for the following month. She ended with a stern reminder: self-help remedies invite statutory consequences. The gavel sounded, a noise softer than Hollywood would have you believe, yet definitive enough to alter destinies. Adam's shoulders slumped. Ella exhaled so deeply the baby startled, then settled. Court reporters transcribed every breath into the public record. Outside, the drizzle had returned, mirroring the night of the eviction, but with roles reversed. This time, Ella carried her child toward the very house that had cast them out, not as guests, but as rightful occupants, under color of law. Adam followed at a distance, flanked by his attorney, already calculating the penalties ticking like a meter. Neighbors peeked from curtains as the bailiff taped the order to the door. Ella inserted her key. The lock, freshly rekeyed yet again under court supervision, turned smoothly. She crossed the threshold and paused beneath the hallway light, the baby gurgling at framed family photos. For the first time in weeks, the air in the living room smelled of possibility rather than displacement. That evening, after Adam collected his belongings, Ella tucked her child into the crib she had once feared would become a stranger's Instagram backdrop. She dialed Marissa to say thank you. Marissa, still at her desk, reviewed case law for the impending damages phase. She reminded Ella to keep a journal, log every anxiety-ridden mile driven between motel and courthouse, every missed shift, every bottle of infant Tylenol, because damages are stories translated into dollars. The next day, the county paper ran the headline, "Sibling Lockout, Thwarted by Surprise Will." Below it, a subheading asked a question reverberating far beyond local gossip. How much is a home worth when the law is on your side? Search engines indexed the article within hours. Tenant rights forums shared it. Law school blogs dissected it. Somewhere amid the digital ripples, Adam scrolled through comments branding him the Airbnb brother. Reputation, once an intangible asset, suddenly felt like something measurable and diminishing. He consulted another attorney about settling before trial, hoping to salvage funds for creditor calls that now buzzed hourly. But settlement talks are another chapter. Tonight, the house lights are off, curtains drawn, rain clouds thinning. Ella rocks her child beside the same window where she once watched patrol cars depart without her. She hums a lullaby that blends with the distant hush of traffic, and for the first time, the baby sleeps without the echo of motel doors slamming in adjacent rooms. I lean back in this leather chair and let the silence speak, because events have unfolded in a rhythm most of us never hear until we are forced to listen. Accusation, documentation, adjudication, restoration. It is the heartbeat of civil justice, steady yet easily drowned by the noise of fear. If you have ever wondered whether paper truly outweighs possession, remember the image of a sealed envelope resurrecting a roof over a newborn's head. I lean a little closer because this is the moment where feelings meet statutes. The first legal fault line beneath Adam's decision is the rule against self-help eviction. California Civil Code Section 789.3, which many other states follow in substance, labels it a civil offense for any owner or would-be owner to change locks, shut off utilities, or otherwise oust an occupant without a court order. The legislature added sharper teeth in 2024, raising the statutory penalty to $125 for every day the lockout lasts when a minor child is involved. Those dollars are not a fine paid to the state. They flow straight to the person displaced, a built-in recognition that hotel receipts and midnight Uber rides cost real money. A few viewers might wonder whether Adam counted as a landlord at all. After all, he never drafted a lease, he never cashed rent checks from Ella. Yet landlord-tenant law in the United States looks beyond paper titles to something called actual possession. If an owner invites someone to reside, even informally, the guest gains an immediate right to due process before removal. Courts sometimes call this a license that ripens into a tenancy at will, and the Uniform Residential Landlord and Tenant Act, last revised in 2025, makes it clear that family members do not lose those protections simply because dinner conversations replace written contracts. That brings us to probate, where the sealed envelope landed with the weight of a signature from beyond. Under the Uniform Probate Code, Section 2501, a valid will speaking to real property overrides the default rules of intestacy that would otherwise split assets among surviving children. For a will to speak, it needs three elements: testamentary intent, capacity, and proper execution. Ella's parents met all three. They signed in front of two witnesses, both of whom were disinterested, and a notary affixed a stamp. The document carried a date later than any prior estate plan, so the doctrine of revocation by inconsistency placed it at the top of the legal pile. Because Adam ignored that hierarchy, Marissa filed what is known as a quiet title action. The purpose is almost poetic: to silence all competing claims to a piece of land by issuing a court declaration of who holds true title. Until the judge signs that declaration, banks hesitate to refinance, insurers balk at coverage, and short-term rental platforms expose hosts to breach of contract suits. In other words, a murky title makes real estate toxic for business. While the probate judge weighs title, the civil court tallies harm. Damages break into three buckets. Compensatory damages reimburse every motel bill, every mile driven, every hour of lost wages. Statutory damages flow from Section 789.3 and accrue automatically like daily interest. Punitive damages, the rarest but most dramatic, punish conduct that shows reckless disregard for rights. California courts reserve those for defendants who knew better and pushed ahead anyway. Adam's text message threatening criminal charges sits squarely in that zone. A jury may read it as proof that he recognized Ella's possible claim, yet chose intimidation over dialogue. Child welfare law adds another layer. The 2023 Child Protection Enhancement Act, now codified at 42 United States Code Section 621, empowers state agencies to intervene when housing instability threatens an infant's health. Though no social worker removed the baby from Ella's care, Marissa cited the statute to argue that Adam's lockout triggered exactly the risk Congress sought to curb. Judges often view child safety statutes as a magnifying glass that enlarges every other cause of action. Digital breadcrumbs sealed the evidentiary package. The reservation receipt from the short-term rental site, the baby monitor feed, and the screenshot of Adam's threat each satisfy the federal rules of evidence on authentication. Rule 901 allows electronic data when a witness can explain how it was obtained and why it is what it purports to be. Ella's sworn declaration did just that, turning pixels into admissible proof. Civil procedure handles timing. After the temporary restraining order, the court sets a preliminary injunction hearing. If Adam fails to rebut the will's validity, summary judgment may follow, eliminating the need for a full trial on ownership. The only remaining question would then be money, and California's discovery rules compel Adam to open his bank statements to show every deposit from those weekend guests. Behind all these statutes lies the 14th Amendment guarantee that no person shall be deprived of property without due process. The amendment is often quoted in grand constitutional debates, yet here it protects a baby from sleeping in a car. The distance between lofty principle and motel carpet can be as narrow as a judge's signature. For everyone watching, 3 practical lessons emerge. First, never assume blood alone secures your right to live in a family home. Record your interest, keep keys to your paperwork, and know the filing fee for an unlawful detainer action in your county. Second, if you suspect a will exists, search until you can swear under oath that you checked every bank vault and browser folder. Courts forgive many mistakes, but they rarely forgive missing documents. Third, remember that threats sent by text travel farther than spoken words and arrive embossed on courtroom monitors. Ella's case is still marching toward its damages hearing, yet the law has already done its most important job. It stopped the lock on a door from locking out justice. I shift back in my chair and let that sink in, because somewhere tonight another sibling is opening a search bar, typing "Can my brother evict me?" and hoping the answer is more than an internet rumor. Adam's footsteps echoed down the porch steps before the screen door had even stopped vibrating, as though shame itself were driving him forward. Ella watched from the hallway window, baby pressed to her shoulder, while his sedan crawled away under the street lamp glow. For the first time, she felt something more complicated than victory, a tangle of relief, exhaustion, and guilt that the same bloodline that once brought them matching bicycles had now paid for 2 sets of attorneys. From her perspective, the system worked, but it worked slow. 6 nights of lullabies in a motel can feel longer than 6 months of ordinary living. She told me later that each procedural form she filled out felt like a toll booth on a road she never meant to drive, yet the tolls kept her moving toward daylight. She wonders if another mother without a helpful clerk or a free legal clinic would still be circling dark parking lots looking for vacancies. Even as she folds laundry today, she hears the clerk's quiet advice echoing, "Probate is next door." Sometimes justice begins with directions given in a hallway. Adam's view is harder to map. In the days after the restraining order, he revealed to a local podcast host that he felt ambushed by legal fine print. He claims he always intended to settle family assets fairly. But mounting credit card debt left him desperate for quick liquidity. The podcast host asked whether he regretted the lock change. Adam paused. "I regret not knowing the rules," he said, then added with a sigh. "And maybe thinking the law cared less about paper than about effort." That line stirred online commentators who argued that effort without legality is just well-intentioned trespass, a notion many property lawyers quickly retweeted. Marissa views the tale as a textbook illustration of preventive lawyering. Had the siblings consulted counsel before emotions flared, a mediated estate plan could have spared everyone sleepless nights and statutory penalties. She tells her junior associates that the best litigated case is the one that never reaches the clerk's stamp. Yet she also admits the courthouse can serve as a necessary firewall between personal volatility and permanent harm. Her closing memo lists 3 takeaways: lock changes, spark lawsuits, digital receipts narrate intent, and a valid will outranks a loud voice. The judge's perspective, gleaned from her written order, underscores the principle of proportionality. She praised Adam for appearing in court rather than ignoring summonses, but expressed concern that he weaponized police dispatch to shortcut civil procedure. Her footnote cited People v. Slav by Bias Drylands, Cardona 2022, which held that invoking law enforcement under false pretenses may be considered an aggravating factor when assessing punitive damages. In plain language, the badge is not a bargaining chip. The community remains divided. Letters to the editor alternate between empathy for a brother drowning in debt and applause for a single mother who defended her infant's stability. Some homeowners confess they never drafted wills and now plan to book appointments with estate planners. Short-term rental hosts debate in forums whether background checks should include evidence of ongoing probate. A real estate columnist sums it up: "Legal uncertainty is the new asbestos, buyers want nothing to do with it." Critics of the system see a deeper flaw: access. Ella's victory relied on a clinic funded by county grants and volunteer hours. In neighboring counties, those clinics have shuttered, leaving litigants to self-represent in a maze of Latin phrases and 16-page instructions. Adam's counsel warned that rising statutory penalties could push financially unstable owners into bankruptcy, freezing properties for years and draining neighborhood vitality. Yet tenant advocates countered that without stiff penalties, self-help evictions would multiply like weeds in a dry season. The tension reflects a national debate: how to balance property rights with human rights in an economy where a single missed mortgage payment can put both at risk. The baby, whom the court papers call minor child, offers perhaps the most innocent vantage. She will grow up unaware that her first crib cameo appeared in a litigation exhibit. One day, when she passes civics class, she may learn that Article 3 judges resolve disputes by applying law to facts, and she might marvel that she once provided both. Step outside the family and you find the rental couple from Omaha. When a reporter informed them their weekend getaway was evidence in a housing suit, they issued a joint statement. We assumed the listing was legit. Their confusion illustrates how platform economy conveniences can blind travelers to the roots of a property's narrative. A home can host trauma as easily as tourists. Then there is you, the listener, wondering where fairness lands when siblings square off under fluorescent courthouse lights. Ask yourself, should ignorance of a sealed envelope excuse a brother who believed he was acting out of necessity? Or is necessity the very reason laws draw bright red lines around shelter for infants? American jurisprudence loves a balancing test, and everyday citizens perform their own version around dinner tables and comment sections. I must also confront my bias. Sitting in this chair, microphone clipped to my collar, I empathize with Ella because her voice reached mine first. Storytellers shape perception by order of appearance. So I comb through Adam's interviews. I review docket notes. I reread the will's conditional language, all to remind myself that legal truth is built from contested narratives, not monologues. If you feel your allegiance shifting with every paragraph, that is the justice system doing its job, forcing you to weigh evidence, credibility, and consequence. Some viewers write asking whether reconciliation is still possible. California's Judicial Council encourages post-judgment mediation, even in family property disputes, citing studies that show emotional closure reduces repeat litigation. Marissa has floated the idea of a structured payment plan that would allow Adam to satisfy damages without selling his truck, provided he attends financial counseling. Ella, for her part, says forgiveness is easier when her child sleeps in safety. Time will test those intentions more rigorously than any cross-examination. Finally, observers scrutinize the process itself. Critics argue the probate backlog, worsened by pandemic delays, effectively punished Ella by forcing her into civil court first. Others note that the same backlog stalled Adam's discovery of the will, so maybe the scales remain even. The bigger question is whether states should create expedited tracks for housing cases involving minors. Bills proposing such tracks have circulated in Oregon and New York, echoing national momentum toward child-centric reforms. Through every lens, maternal, fraternal, judicial, societal, this case becomes less about square footage and more about the architecture of accountability. It reminds us that law is not a distant tower, but the framework through which ordinary doors stay open or slam shut. So, as raindrops start again outside my window, let me leave you with the question swirling through courthouse corridors and kitchen tables alike. When family and property clash, which locks should stay firm and which should yield to compassion? Night drapes the neighborhood in velvet, and the windows of Ella's house glow like quiet lanterns, proof that peace sometimes needs a courtroom to bloom. She rocks her daughter beneath a string of paper stars and finally lets her thoughts wander beyond tomorrow. Yet the echo of the judge's gavel still hums, reminding us that a story ends only if we learn from it. 3 weeks after Adam walked away with cardboard boxes and regret, the court met again to talk numbers. Motel invoices, pediatric co-pays, rideshare receipts, and a stack of pay stubs showed exactly what the lockout cost. On top of those dollars, the judge added the penalty set by California Civil Code Section 789.3, $100 for every day a self-help eviction lasts. And because an infant was involved, she treated each 24-hour stretch as a separate wrong. The total award eclipsed the weekend rental income Adam once chased. Shortcuts, it seems, carve the longest roads. Money aside, the ruling sketches a plan anyone can follow. First, keep proof alive. Photos of a locksmith drilling a lock, screenshots of threats, even a baby monitor clip from a stranger's tour can all become evidence when you can testify how you captured them. Second, guard your paperwork. A will that is signed, witnessed, and notarized under the Uniform Probate Code outshouts any last-minute claim. Store a copy where fire and arguments cannot reach, and tell someone you trust where to find it. Third, ask for help early. Every state posts self-help guides, and most counties fund legal aid clinics for wrongful eviction and probate issues. The phone call Ella made to a free clinic cost nothing. The silence Adam kept cost him nearly everything else. Of course, no statute pays the emotional interest that gathers when family fractures under fluorescent courthouse lights. That is why a mediation session sits on the calendar. Ella will consider a payment plan, allowing Adam to keep a roof of his own while he repays the roof he nearly took from hers. The clerk calls that restorative justice. Ella calls it showing her daughter that forgiveness is enforceable too. Neighbors keep debating the verdict. Some cheer a win for single mothers and tenant rights. Others worry that stiff penalties could bankrupt small homeowners. Legislators in Sacramento already float bills to fast-track probate when minors are at risk. Proof that one porch light conflict can ripple into statewide policy. Through all of this, the law moves in its steady rhythm. Due process, hearing, written order, right of appeal. It may travel at the pace of paper, but paper endures where shouting fades. That quiet triumph flickers tonight in Ella's dining room lamp. So let us turn the lens toward you. If tomorrow someone taped a notice to your door, or a relative claimed that an unwritten promise outranks a notarized deed, would you know which courthouse desk to visit first? Would you have copies of your lease, your will, your receipts? Justice is not a stranger waiting at the top of marble steps. It is a habit formed long before the rain begins. I end where I began, in this worn leather chair, listening to the clock tick through another minute of someone else's life. And I leave you with one thought that outlives lumber and siding. In the house of American law, doors rarely stay shut when you carry the right keys, and those keys are forged from knowledge, documentation, and the courage to knock. What would you do if the lock on your past tried to close off your future?